Okay, good morning everyone. My name is Dr. Vaibhav Gunyal and I'm going to tell you about equality today. That means the topic for discussion is going to be very important one. Important for three main reasons. One, your examination. The second, if you talk about judicial service examination, and the third, if you talk about any other competitive examination. Article 14, that is a general form of equality. Let me tell you and clear things out initially itself. And when we come directly to that, before I start with that, I should just like to give you a background that we are talking of Magna Carta of the Constitution. That means Part 3 of the Constitution of India, that is your fundamental rights. See, students, when we talk about right to equality, it is basically a chapter, it is not a single article. That means Article 14, 15, 16, 17 and 18. This comprises right to equality in India. We are right now concerned only with the Indian Constitution. That means the Constitution of India 1950. And when we talk about this equality, it has been bifurcated in different terms. That means when we say Article 14, it only means a general form of equality. You need to note that down. That means only general form of equality. Article 15 talks about your non-discrimination. That is also a form of equality being practiced in India. We'll have to talk about that also later on. But today's topic, it shall be based on Article 14 itself. Okay, when we talk about this right to equality, students or anyone, whoever is watching this video, when we talk about this Article 14, it simply means that we are talking of one of the most important rights available there for any nation, any democratic nation, first thing. And that means equality, that the concept is available in any democratic nation. And when we talk about India, that means our Constitution of India 1950, also known as the Supreme Law of the Land, by virtue of Article 13, as well as the Grundnorm term that has been given specifically by various authors. The best example, that is your Professor Narendra Kumar, page number 1 of his book, by the way. That person tells that the Constitution of India is the Grundnorm. Moreover, the Honorable Supreme Court of India in Ayyar Koholo vs. State of Tamil Nadu also stated this term Grundnorm. But the point is, we are discussing a very important document and a very important part of that particular document. That means we are talking about your equality. Okay, now coming straight to the point, Article 14 of the Constitution, students, it is a single line, very easy to be understood and very easy to be remembered also. That is, the state shall not deny equality before law and equal protection of law to all persons. Important elements to be noted under Article 14, that is, one is your person. That means it is a personary right. It is not a citizenry right as compared to Article 15 or maybe your Article 16 also. When we talk of reservation in particular, for example, just a small example, we are talking of a citizenry right. That means you ought to be a citizen of India, then only you will be able to get those rights. You will be able to avail those rights if you are a citizen of India. But when we talk of Article 14, it is a personary right. When you say personary right, it means it is available to everyone. That means whoever is coming in this nation, that person may be a citizen, that person may not be a citizen, that person may be a national of this nation, that person may be a resident of some other nation, whatever the conditions are, equality shall be available to everyone. So that means a very generalized concept. Article 15, although, that means it is also a part of equality, which you will have to study later on in the chapter that will continue, that means your equality. Over there, when you go, it is written over there that all citizens of India. When you talk about Article 19, that also mentions all citizens. That means it is a citizenry right only, other than Article 14, because Article 14 is your personally right. One thing, very important. Second, when you say equality before law, that is a different term. And when you say equal protection of law, that is a different term altogether. That means both of them have to be distinguished from each other, and then only you will be able to understand the crux and the core of your Article 14. Okay, then starting with that, as already told, and you can see in your Bare Acts also, just refer to the Constitution of India 1950 Article 14. It simply states that the state shall not, the point is the state shall not. Again, the term shall becomes important because it provides mandate. Whenever you use the term or you read the term may anywhere in a statutory provision, it simply means that it is a discretionary point for that particular entity or authority. But whenever you say the state shall, the term shall becomes over here as a mandate. So the state shall not deny any person equality before law and equal protection of law. That is what your Article 14 is. Another thing very important when we talk about this, it tells you only equality among equals. That means you need to understand, students, that whenever we are talking of equality, we are talking in under Indian context, we are talking of equality among equals only. That means we will never say that everybody is equal. For instance, in your YouTube channels, maybe also in your other social media, you might have heard that okay, everyone shall be equal. The condition is not so. The condition simply states that people who are equal shall be treated equal. That means again equality will be there only among the equals. Everybody cannot be equal. That means, and the context. See what happened when the Constituent Assembly debates were going on. The point of discussion was, can everybody be treated equal? So obviously it cannot be done. For the point that if God has not made you equal, how can you make people equal? That means the CAD debaters, they are talking of a country, a nation in building, that a constitution will be formed. And then they are saying that, okay, this document, through this document, we will provide equality. But what kind of equality will be there? Everybody, if treated equal, that shall be injustice in the society. If I give you an example on this point, you say that, okay, if we say two contexts we can take over here. One, that males and females, they are being treated equal. So see, imagine a condition that, okay, males and females, if they are equal, transgender also, we are saying everybody is equal by one context. In this context, now what happens if a 100-meter race is going on, everybody is going to participate because everybody is equal. What is going to happen now? Injustice to the weaker sections in statistical terms. Exceptional cases may be there, that okay, there is a girl who has joined gym, or maybe she has built up her physique in that manner, that okay, she will easily win that race. But statistically, what is going to happen? Injustice to a female sector as well as to a third gender sector. That is the only reason why stratification is being talked of over here. That at one instance, just make stratifications. That means reduce these three categories in different terms: males, females, and third gender. When you have stratified them, now what you are going to do? You are going to provide for equality among that stratification. You are not going to treat all of them equal, you are just going to treat that particular section as equal. This context becomes very important when we talk about your reasonable classification. That context I will explain it to you in the upcoming slides, but the point is you need to understand it here itself, that we are talking of equality among equals only. Everyone cannot be equal in this nation. Only those who are equal shall be ordained or shall be termed as equal. That is the context, very important one. Okay, when we talk about equality before law, the point written over here in this slide, that is your English origin. From England we borrowed this, the Constitution of India. If we talk about the 1950 document of 1950, it tells you that the Constitution, if you read it in whole, you just come to know that it is a research document. We borrowed so many features from so many different nations. Similarly, when we talk of one feature, that is, we are talking of equality before law right now. There are other features also which we borrowed from England, but yes, equality, that means equality before law. This context has been followed from England. We call it of English origin. The point again over here to be understood is, it is a negative concept. Why negative? For the reason that it is not providing any special privilege for anyone. If you are saying equality before law, understand this point please, that whenever you say that everyone will be equal before the law, that means privilege will not be given to anyone. All will be treated equal, nobody is going to be treated in a special manner. So that is the only reason why you term it as a negative concept. That means if everyone is equal, privileges have been cut down for everyone. If you say Article 15 Clause 3, for example, though it is not a part of the discussion, but just for an example, for a small example, if you say that special privilege has been given to women and children, so in the context of your equality before law, if a nation follows the concept of equality before law, it becomes negative. Why? Because that privilege ought not to be given by this term, if this term is used. That is the only reason why the Constitution of India 1950 under Article 14 enshrines both elements, equality before law as well as equal protection of law. If you simply say equality before law, it will be like, okay, arbitrary term. For the reason that there will not be any privilege given to the weaker section of the society. So whenever we say weaker section of the society, very broad term, and every category which you term as weaker section, it will not be privileged. That is the reason why we are calling it a negative concept. Okay, we talk about your equal protection of laws now. Equal protection of laws, on the other hand, it is completely different. It talks about your positive concept that the state's obligation is to protect the equality or the privilege which is being granted. That means now the state is taking in its hand, the state is going to protect your rights, the state is going to protect your fundamental right. That is particularly Article 14, which is the point of discussion. So that means now it becomes a positive concept over here, for the reason that state is going to protect, state is guaranteeing you. Now understand one thing, very important, students, again, that whenever you say fundamental right, it is upon the state that how it is going to protect that. The state is the guarantor of your fundamental rights as well as the protector of your fundamental rights. That means fundamental rights, they are being given to you by the state. A private individual will not be able to give you fundamental rights. Similarly, if the giver is the state, the protector is also the state. It is guaranteeing that these will be protected. So that is why whenever the state is saying that, okay, equal protection of laws is going to be there, that laws are going to be protected equally for everyone, it becomes a positive concept, because the state is taking in hand, the state is guaranteeing that protection will be there for every person. Person, for the reason that personally right. Article 14 is a personal right. Okay, we come to reasonable classification, that when we've talked about these three elements, one is your person, which has been mentioned under Article 14, it makes it a personally right. Second is equality before law. Equality before law means equality among equals, though a negative concept. And third, that is equal protection of laws. That means the state guarantees that the laws are going to be treated in an equal manner. That is your positive concept. We come to reasonable classification now. Why reasonable classification? The first question, the reason for that is, the reason for reasonable classification is your stratifications. The concept of equality among equals. If you are saying only equals are going to be treated equal, so that simply means that you need to classify them but in a reasonable manner. Always understand one very important thing, students, over here. Whatever classification takes place, wherever classification takes place, it has to be reasonable. The term classification is not alone, it is being used with the term reasonable. That means again, the classification has to be reasonable. Though the term reasonable has to be interpreted by the judiciary. The legislature is not going to interpret reasonable for you, it is only going to make laws. But the judiciary is going to interpret reasonable as said by the court in Chintaman Rao's state of Madhya Pradesh. Important judgment. You'll have to read that again in your article 19 whenever you talk of the term reasonable. But over here also and everywhere wherever the term reasonable is used, you need to quote that the Honorable Supreme Court of India in Chintaman Rao versus State of Madhya Pradesh had already said that the term reasonable is going to be told or interpreted by the Honorable Court itself. That means the judiciary is going to tell you that. Okay, when we talk of this reasonable classification, specifically under your article 14, it simply means that it must be founded on an intelligible differentia. And second, there are two important elements to be understood over here. One, that classification has to be founded on a term that is your intelligible differentia. And whenever you say intelligible differentia, it has to have a rational relation. That means it has to have a rational relation to the objects or to be achieved. That means if you say, I'm sorry, I use that term. Okay, if you say that, okay, classification has to be founded on intelligible differentia, it simply means that you are differentiating between two categories, you are stratifying them, but in reasonable terms. Intelligently, you are classifying that. It has to have some object, it has to have some reason. It cannot be classified on like, okay, just arbitrarily you have classified two categories. You cannot do that. You have to provide some intelligible differentia. You are differentiating, but using your intellect. That means again, intelligibly using your intellect, you are differentiating that, okay, this category cannot be rated equal to that category. That is what classification is, founded on the principle of intelligible differentia. When you say differentia need to have a rational relation with the objects or to be achieved, it simply means that the object for which you are classifying, that needs to be achieved by this kind of differentia. You are differentiating, you are saying intelligibly you are differentiating because every common prudent person can see that, okay, there is a difference between two categories. You cannot just treat them both equal. But again, this differentia has to be sought for the object which you are seeking. Why are you differentiating? There has to be an object behind that. And that object should not be defeated by that differentiation. That means what your original intention was behind differentiating the category, that has to be followed. You cannot defeat that, and that is the only point behind the object which is being sought to be achieved. You are achieving the object that, okay, this category has to be differentiated. For this reason, whatever it may be, that object should not be lost. Example for this can be found out with a case law. I have mentioned it over here. That is K.A. Abbas versus Union of India. Very important one for your Article 19 as well. But it flows from the very concept of equality. That is from the concept of your Article 14. When you talk about K.A. Abbas versus Union of India, you also call it as a film censorship certificate case. That means again, what happened over here? The censorship certificate provided by the censorship board in India. That certificate was questioned in K.A. Abbas versus Union of India. There are two kinds of certificates. It is like a general knowledge for everyone. That means your U certificate and A certificate. A certificate is provided to those feature films which are there to be seen only under adult supervision. Very easy, and it is like, okay, very well known concept. And second, when you say talk about U certificate, everybody can watch that kind of a live streaming or movie or whatever it may be. That means we are talking of an electronic media. In electronic media, whatever is being broadcasted, that is divided into two. That means again, censorship board, it divides them and it says A certificate for certain films, or maybe other kind of broadcasted media or media that is going to be shown to everyone in whatever manner it may be. And second, that is your U certificate that will be given for movies or maybe your whatever type of videos you are watching, which can be watched by everyone. Adult supervision won't be required. In K.A. Abbas versus Union of India, the question over here, student, was that discriminating in these terms, it is against Article 14. That when you talk of equality, now if you are discriminating that media, you say media, electronic media and print media. We are not concerned with print media whenever we are talking of this censorship certificate. We are only talking about electronic media. Further on, when you say electronic media will be divided into U certificate movies and A certificate movies, so that's or videos maybe. So that simply means that you are again discriminating and you are again classifying them. So this question was questioned before the Honorable Supreme Court of India that, okay, is that in favor, that means is that in connotation with your Article 14 or is it against your Article 14 of the Constitution of India? That is what was the question. But the Honorable Supreme Court of India said that this is a sheer case of your reasonable classification. Movies and videos need to be classified on the basis of the point that whether it can be viewed by everyone or whether A certificate, that means adult supervision, is required or not. So this was held by the court as your reasonable classification, the best example that can be given for this particular heading. Okay, when we talk about this case, students, one thing very important which comes to mind is that, okay, we talk of a certificate and we talk about that content which cannot be viewed without an adult supervision. So we are basically not meaning only for adult films. That means we are not only talking about obscene materials, we are also talking of that material. It may be too violent for children to view. That means again, the sector, the population that is not your adult or that is not completely your children. You have a mixed population. And whenever you say that, okay, this population is going to view that particular media. So it depends what can be shown to which category. If we talk of children, they are vulnerable minds of the society. And if you show them every content, the future of India, that will be again in a question. So the point which comes out over here is whenever you say that, okay, A certificate movies, it does not simply means obscene. Obscene is covered over there, but along with other things also. An extremely violent movie may also be given that A certificate. And when you say A and U certificate, that is not discrimination. That is an example of your reasonable classification under Article 14 of the Constitution of India. Okay, next thing that we'll have to discuss, that is your class legislation. We say reasonable classification on the one hand, students, but at many instances it may happen that class legislation may take place. Class legislation is prohibited in law. That means again reasonable classification is permitted. You are permitting it because again by the same concept that equality among equals only equals can be treated equal. That means you need to classify them, but that classification has to be reasonable. But when we talk on the other hand, there may be your class legislation also. Now what is that class legislation? Easily understood by a very important case, that is your Sunil Jaitley versus State of Haryana. See what happens, student, over here is students, that means again who have cleared their ISC, maybe 12th standard, it may be CBSE, it may be ICSE, whatever they are referring to. But yes, students who have cleared, now they want to take admission in your medical field or maybe in other academic institutions for their higher education. But these people are being denied admission on the basis of rural and urban. This classification was made by the state. That means children who have taken admission, their primary education, children who have taken their education, the primary education we are talking of up till 12th standard. If they've taken their primary education from some rural area, they will not be allowed for this higher education. And if they have taken, on the other hand, from some urban area, they will be allowed for that admission in that higher education educational institution. That means again this classification was made over here. Now the question before the Honorable Supreme Court of India, which was laid down, was that is this an example of reasonable classification or is it something else? The court called it class legislation, students. That is an example of class legislation and it has been prohibited by law because they say that there is no intelligible differentiation behind that. You have already seen that in the previous slide. I explained thing to you. That means two things have to be sought. Whenever you classify categories, you need to find out whether there is an intelligible differentiation, that you are differentiating on some logic, some reason is given behind that. And the second important thing, the object for which you are discriminating, it should not be defeated. You have to fulfill the object why you are discriminating. Now discrimination over here, if we talk about admission in your higher educational institutions, why discriminate on the basis of rural and urban? One thing. That means again, the object that you are seeking is good education. That means you just want a good education system to be delivered to everyone. Moreover, right to education, that is a fundamental right, Article 21A, added by an amendment, but yet it was before amendment also, it was a fundamental right in your Article 21 itself. That means Article 21 in a circumscribed manner, it contained your right to education also. Later on 21A, it became right to education. When you're talking of such kind of concepts in India, that means everybody should get that education. Why are you talking of classification now? Now one thing is primary education, there you provide right to education. Okay, taken. And then when you say that secondary education, that means your higher education, right to education is not available over there according to the fundamental rights enshrined in the Constitution of India. But the point again is the reason, the object behind that. Why are you providing this right to education? If you talk in general terms, the first answer that comes to your brain, the first answer that you give to anyone is that, okay, every citizen ought to have that education for a better nation. That means, okay, you want to advance, you want to move ahead further. So that means you need to have education at the forefront at the outset. You need to have that education system. And now you are saying that, okay, on the basis of rural and urban, you are classifying that. So that is the reason why it was termed as class legislation. Because one thing is, what is the object being sought? The object that you are, if we talk about this education system in India, you are talking about, and the main objective is that, okay, everybody should get that. And everybody should rise. Education is very important for every person to rise up in life. But point over here is that, okay, that object which has to be achieved, that object is not being achieved by this kind of classification. That is why it is not reasonable classification. It becomes your class legislation. And this class legislation has not been made available in the Constitution of India. That means it has been prohibited. Such kind of classification cannot be there. You have to classify because equality among equals only. Only equals can be equal. That means people who are equal, you can treat them only equal. You cannot treat the general population as equal. But when you say that, okay, there is no intelligible differentia, or maybe the object which is being sought by that particular thing is being defeated, then one particular thing comes in mind, that it is your class legislation. If you are not able to defeat that object, then you may say, along with that intelligible differentia, then you may say it is your reasonable classification, else it becomes your class legislation, as explained by the court in your Sunil Jaitley versus State of Haryana. Very important case, you need to understand that and you need to remember that also. Okay, next comes your new concept of equality. Up till now, equality was based on two general concepts. That is your reasonable classification and then your class legislation. Reasonable classification accepted in India, it has to be there mandatorily. And when you talk about your class legislation, that is prohibited in law, Sunil Jaitley wala case, which I had already explained. Okay, now when we come to about this, we talk about that new concept of equality. Why are we calling it the new concept? For the reason that up till now, what was being discussed? Intelligible differentia, reasonable classification, class legislation. But now we are talking about a new concept which has been formed. That means the court in E.P. Royappa versus State of Tamil Nadu empathetically made another strategy. The court simply said that we will not check any intelligible differentia or the object whether it is being achieved or not, or maybe your reasonable classification or class legislation. There is only one single test, that is your arbitrariness. If there is arbitrariness in any statute, you will simply call it against Article 14, that means against your equality. Because when you say arbitrariness, it simply means that there is no reason behind making something, there is no justification, the law has been made in any manner, whatever it may have been thought as to be made. The point which comes out from here is the sole test for equality or inequality whenever you are testing it out. That is your arbitrariness. Presence of arbitrariness means Article 14's infringement. Article 14 obviously which we are discussing, that means equality has been infringed. So that is the new concept of equality after E.P. Royappa versus State of Tamil Nadu. Okay, one very important case again, so that this thing becomes clear, that is your Ajay Hasia versus Khalid Mujib and allocation of seats. See, one thing is, students, whenever you appear for a competitive exam, that means we are talking of your standard competitive exams in general, I'm saying, I'm not talking about everyone, but the condition, the strategy being laid for selection, that is your pre-exam, then you have your mains, and then you have to face your interview. When we talk about this pre and mains, if you clear that stage, now you face your interview. But whenever you get the marks, weightage has to be given to all three of them. That is what the point is, which has to be discussed in Ajay Hasia versus Khalid Mujib. What happened? The candidates who cleared the exam and now when they are facing the interview, they had a complaint and they just said that the 1/3 of that total marks was based on interview itself. That means the marks, it is being based on interview for selection criteria. Major of them. I'm not saying that the entire thing was depended upon the interview, but the major portion of the marks, it depended upon the interview. That was wrong. That is against your Article 14, and that is why, because now we are talking of arbitrariness. See, we are not talking of intelligible differentia. We are not talking of any kind of classification. The only thing that is being told over here is that interview had more weightage. The marks of interview had more weightage for selection of a candidate. And that thing is being questioned. That thing was questioned in Ajay Hasia versus Khalid Mujib on the basis that it is arbitrary. It cannot be done. And whenever you say arbitrary, that means now you will not have to focus back on your reasonable classification of class legislation. The only thing is, if you are able to prove that a law is arbitrary in nature, it will be called as against Article 14. And this was proved very easily in Ajay Hasia versus Khalid Mujib that this cannot happen. Equal weightage has to be given, or maybe whatever the proforma, the format might have been given. But now, paying attention to this case, the facts of this case, simply what happened? Interview marks were given more weightage as compared to your pre or mains, and that is the only reason why the Honorable Supreme Court of India called it arbitrary and against Article 14. This was violative of Article 14 of the Constitution of India. That is what is meant by arbitrariness. So that means up till now, whatever had been there before E.P. Royappa State of Tamil Nadu, it was like reasonable classification or class legislation. But from now on, what happens after E.P. Royappa State of Tamil Nadu, a new concept of equality has emerged. That is test of arbitrariness. That is the sole test for finding out whether a statute is infringing or abrogating or is inconsistent with Article 14 of the Constitution or not. Article 14, that means present in the Magna Carta of the Constitution. So that is what your Article 14 is. I hope you did understand it. See, students, once again, I just need to remind you, I should say, that equality is not just Article 14. Right now, we have just discussed the general concept of equality. Equality moves on further ahead with 15, 16, 17 and 18 articles respectively of the Constitution of India 1950. So that means we've just discussed the general term, generally what equality means, and that is first thing a personal right. Second, it consists of, or when you read Article 14, you just say that okay, You are talking of equality before law and equal protection of law. Along with that, two concepts, that is again your intelligible differentia being used and the objects are to be achieved, is being seen as if not to get defeated. And then you say, okay, reasonable classification and classification. But that concept was there traditionally. Before A.P. Roy State of Tamil Nadu, that was the condition. After A.P. Roy State of Tamil Nadu, now the condition is the sole test of arbitrariness. That is enough to check out that whether a statute, a provision, a law, whatever it may be, it is infringing Article 14 or not. That is what your Article 14 of the Constitution is. I hope everybody has understood that. Thank you.